Good afternoon. I'm Josh Andrajak, president of Boley Featherston Insurance in Wichita Falls and an IIAT board member. Thank you for joining us for another virtual InsureCon session. I hope you have enjoyed the earlier sessions with Steve Anderson, and just in case you missed those, all of the virtual InsureCon sessions are being recorded and will be available at the iiat.org website on Monday of next week. Before we get started with this session, I have a couple of announcements. First, I want to extend my heartfelt thanks to IIAT's lead underwriters for making this virtual InsureCon possible. It is because of their generosity that this program is free to all members of IIAT. So we want to thank Union Standard Insurance Group, Texas Mutual Insurance Company, UFG, Allied Trust, Central Insurance Companies, Service Lloyds, Liberty Mutual Insurance, Safeco Insurance, Imperial PFS, Travelers, State Auto Insurance Companies, Nationwide, Swiss Re, and IIAT Advantage, E&O, and Markets. I also want to remind everyone that IIAT Advantage E&O's Carrie Sinevsky and Gunnar Kephart will be presenting a webinar entitled E&O Risk Management, Meeting the Challenge of Change, this coming Tuesday from 1 to 4 p.m. During that 3-hour webinar, you'll learn about the life cycle of an E&O claim, documentation techniques, E&O considerations for agency operations, and more. It is also approved for 3 CE credits. To register, go to iiat.org/education or look from an email from IIAT with details. Now I'm excited to welcome our panel of experts for this afternoon's session. They are Richard Lund, JD, Senior Underwriter and Vice President and Risk Management Coordinator for Swiss Re Corporate Solutions, Jim Redeker, JD, Vice President and Claims Manager at Swiss Re Corporate Solutions, and Susan Taylor Wall, JD, and partner at Gordon and Reese, National Coordinating Council. And with that, I'll turn it over to the three of you.
Thanks, Josh. This is Richard Lund. As Josh said, I'm a senior underwriter, and I'm also the risk management coordinator for Swiss Re Corporate Solutions Insurance Agents Professional Liability Program. I want to thank you all for joining us today. Give you a couple little housekeeping things. All of your phones are on mute, so that'll make it a little bit easier for you. Also, if you have questions, we may not be able to have time at the end to answer them, but please, if you have questions as we go along, put them in the chat box, and we'll respond following the webinar. I also want to thank our other two panelists for joining us, Jim Redeker, who I work with, and he is a claims manager at Swiss Re Corporate Solutions. Jim and I have worked together for quite some time, and we've been doing these webinars on risk management for insurance agents for several years, and we want to thank Jim for coming along. Also, we have Susan Taylor Wall. She is our National Coordinating Council on COVID-19 claims that are going to be happening, that we expect to happen all over the country. We'll be talking a lot more about that. We want to thank Susan for joining us today, too. This is also a rare opportunity for you all because you have 3 lawyers, and if you want to ask questions, it's not going to cost you an extra nickel. So please feel free to ask those questions as we go along. As I said, we'll get back to you as we go along. We're going to be starting our discussion today about what we have been doing in regard to the problems that have come about as a result of the COVID-19 coronavirus. The Big I, we have been working very closely with the Big I since actually about the second week of March to try to address the issues that have been presented to you as agents and to us, to our members, to our policyholders and the members of the Big I. And the Big I actually has put together a Big I, their COVID-19 website. I would really ask that you go there if you have any sort of issues regarding the operations of your agency. There's lots of great information there about how to deal with the issues that you're having on a regular basis because of this change. I know many of you have had to go from working in an office to then having you and your staffs working from home. And this has obviously been a big part of what we've all been doing for the last several months. There is information there from the Agents Council for Technology. They have a disaster planning toolkit that provides information about teleworking, remote working environments, and staff coronavirus illnesses and sick leave and how you can address those issues. They also provide work from home best practices. And also there's some things there about that come from a risk management standpoint as well, and it's the carrier responses to claims. You probably have received some from some of your carriers notifications that you should be notifying your customers that there may not be, or that there is not coverage for their business interruption or business income claims. We're going to talk a little bit about that, but there's great guidance from the Big I on that, and I would certainly recommend that you go there. In addition to that information solely from the Big I, we also have on the Big I website the E&O Happens Risk Management resource page. What this is a collaboration between Swiss Re Corporate Solutions and the Big I to provide you with the best risk management kind of issue or information to help you try to avoid the problems that you may have when you're dealing with the COVID issues, but also just general issues in regard to risk management. So please take advantage of the resources that are available to you. To get into many of the things that are available on this page, if you're a Swiss Re Corporate Solutions policyholder, this is exclusive to those people that are Swiss Re Corporate Solutions policyholders. You may also be known as Westport, and you'll need your login for that. So be sure to contact Carrie or Gunnar or any of the other staff to get that information. So on April 7th, we conducted a webinar that was directly related to all of the issues that we had at that time in regard to COVID-19 and E&O best practices. I'm not going to have time to go through that. We're not going to have time to go through all that today, but I would certainly recommend that you go there and take advantage of the webinar so that you can understand the information that we've been generating to try to help you avoid the issues that you may have from an E&O standpoint when you're dealing with your customers. And we do expect that there's going to be some problems, and we're going to be talking about all those today. We've talked about various things, and we're going to be talking about those also today so that you hopefully can have information at your fingertips to help you prevent an issue that might come about later. Jim, we're going to go to you. You and I have been in virtually daily contact since about the middle of March on this. And so I want to have you kind of address the situation that we've got so far. What kind of claims have we been seeing in regard to claims that have been made against agents as a result of the COVID-19?
Well, Richard, I have a map here that shows 21 claims and potential claims that we have seen so far from our insureds. This map is already out of date because we have a 22nd one that has been reported as well now. So these are still coming in. At this point, they are merely trickling in. But a lot of what we're seeing are claims that have to do with business interruption or business income claims off of property. We've only had 2 lawsuits. We've had a couple of claims that are not in suit. Most of these are reported as potentials where customers, clients of the agents have been told that their property policy isn't going to cover and they're not happy, and they've said that they're going to sue. And so the agents have reported those out of abundance of caution. As you can see right now, they're sort of clustered along the East Coast, and they're kind of in the Ohio Valley in that area and such, with a couple others smattered around. We think they're going to be much more widespread than this. Right now, a lot of courts are not open yet to file suits, so we don't take a lot from this, but this is sort of what we've seen so far. And a lot of what we're seeing are what you would expect: local small businesses that have been shuttered by the pandemic, including restaurants and bars, caterers, theaters, fitness clubs, etc.
Jim, and obviously it looks like we're still in the early days, even though we're 3 months in now. But I'm assuming that we're still expecting some other things before this is all said and done.
Well, yeah, we are, Richard. And normally when I address a group of people like this, it's usually following a hurricane. And I would have several past hurricanes to look at, to extrapolate data from, to talk about what to expect. But since we haven't seen a previous pandemic, I have to look for data elsewhere. So for starters, you've all seen the chart up at the upper left hand from Johns Hopkins University. This one shows the number of cases the number of COVID cases as a percentage of the population. The darker the color, the higher the percentage, which tells you that these are the heavily impacted communities and areas where we're more likely to see claims, we feel. Also then, at the upper right, you'll see states in red that had statewide business closures. Now we're seeing the plaintiff's bar rely on closure by civil authority as a trigger for most business interruption claims in the suits that they're making. So we believe that, you know, the majority of the states all had these civil authority closures. So that makes all the states in red pretty much game for those claims. The last thing you see is the impact by state on unemployment in the wake of both mandatory and self-quarantines. The darker the color, the more severe the economic impact, which most likely will mean more business interruption claims.
So I guess what we're saying is it's fair to say that there's going to be more claims coming.
Well, yeah, that's pretty much what we assume, Richard. So you have to bear in mind that the first target of these lawsuits is not going to be the insurance agent. The first target is going to be the carrier who denies the business interruption claim. It's much the way that we see following a hurricane. It's the carrier that's the first target. The chart that you see here is posted online by Huntoon Andrews Kurth Law Firm. It starts to put some hard numbers in front of us. And I suggest people go there and take a look at this. This information is already out of date and has moved up. So as you can see, this is as of June 9th. But as of June 9th, over 2,600 lawsuits have been filed in the United States involving COVID-19 claims. And as you can see, 170 in Texas alone. So the darker the color, yes.
Jim, let me just make sure we understand. Then these are all lawsuits. These are not lawsuits just against agents. Is that right?
That's correct. These are all COVID-19 lawsuits. So the darker the color, the more claims the state has, and the highest tallies are shown to the right. But those aren't the only states with suits filed. Every state has at least one. And some of these suits, insurance agents are sued. They're included as well. In others, it's just the carrier that's sued for now. But as we've seen with hurricane claims, if they don't get satisfaction through the carrier, the next step will be the agent. So, as I say, note this website, and you can kind of keep track of the activity in your own state to see how litigious things are on COVID-19. And as I mentioned before, some of the states are just getting started because their courts were closed and filing suspended.
So, Jim, we're 3 months in. Why are there so many claims that are or lawsuits that are being filed against or getting filed so soon?
Yeah, it's kind of strange with everything shut down, people working from home, how quickly it seems the plaintiff's bar has gravitated to this. However, if you Google COVID-19 and lawyer, you'll have your answer. There have been advertisements there for quite some time looking for businesses and individuals to sign up. It's not only that, the plaintiff's bar is working together in ways we've never seen before. So here, for example, you'll see a mailer that was sent out by 4 nationally recognized Missouri law firms that ordinarily work on their own, but they're cooperating here as a COVID-19 business litigation group to go after carriers denying BI claims. It won't stop here, though, because if you read the first sentence, business interruption insurance policies are individually crafted to the insured's business. So it doesn't take much to see that when the carriers balk at paying these claims, they're going to turn to the agency that was supposed to do the crafting of these policies. So this, of course, begs the question, how do we respond on the behalf of our insured agents and brokers?
So, Jim, kind of looks like we're in this for the long haul. What can you tell us about how we are going to be addressing this going forward?
Well, I'll tell you, Richard, and as everybody on this call knows, in the past we've relied on our well-established panel firms to handle the claims against our insureds. This approach has served us well, with the exception of Hurricane Katrina. Following Hurricane Katrina, we saw claims increase in New Orleans by 1,000%, and our law firms in New Orleans and the surrounding areas became overwhelmed with the work. In the end, the number of cases were too much for our panel firms, and we had to hire firms we had never used before. Thus, many of the agencies didn't get to use the firm they wanted, and some did not even get a panel firm. Now, we tried sharing strategies and successful motions we had used in other cases amongst the firms, but ultimately these firms had to get up to speed handling agents' claims, and many handled cases their own way. That brings me to the right-hand side of this slide. So we've decided the best approach to handling the expected onslaught of COVID-19 claims is by utilizing National Coordinating Council. By using a National Coordinating Council, we hope to provide a consistent defense to our insureds and not overwhelm our panel law firms. This method is described as a hub-and-spoke approach to defending cases. Our National Coordinating Council will act as the hub, receiving every case, reviewing it, and then assigning it to a local office within their firm. National Coordinating Council will help develop a consistent defense strategy to be used throughout the country. The firm's local attorneys will then tweak that strategy based on local law, precedent, and judicial realities of the court their cases are in. Furthermore, National Coordinating Council can strategically select cases for appeal to maximize our chances of a favorable outcome and create good law that'll have the broadest possible impact for all our insurance agents. Finally, by using such a firm, we'll ensure having the bench strength to handle the onslaught of COVID-19 claims that may be coming, including the much talked about class actions.
So, Jim, we introduced one of our other panelists, or our third panelist today earlier, and that's Susan Taylor Wall. And I'm assuming that she is our National Coordinating Council.
Yes, that sort of takes out the surprise. But yes, our National Coordinating Council we've chosen is Susan Taylor Wall with the firm Gordon & Rees. Susan is located in South Carolina and has been successfully handling our insured E&O claims for over 20 years. She has a deep understanding of insurance agent E&O law and is affiliated with the nationally recognized defense firm of Gordon & Rees. Gordon & Rees has 40 years of experience defending professional liability claims, and they have offices in all 50 states. At this time, I'd like to introduce Susan Taylor Wall. Susan?
Thank you, Jim. I appreciate the opportunity that I've been given to serve the interests of independent insurance agents and brokers in this very unusual and challenging time where we are expecting many claims to be made against agents and brokers. Let me briefly discuss first our national strategy in handling claims against insurance agents and brokers related to COVID-19. The interests of the client, which is The interest that we have in you as the agent and broker is our first priority. We understand and we appreciate that you have important relationships with your customers and also important relationships with the carriers whose policies you sell. Thus, your business interests are a part of the strategy in defending these unique claims. We are very sensitive to litigation approaches that are counterproductive to protecting your interests. The focus, of course, is on defeating the claims that are going to be brought against agents and brokers, either through motion practice, where the complaint, for example, is deficient, or through discovery by requiring that the plaintiff prove its case as to the agent. We do not intend to become embroiled in coverage, remembering that the policy was drafted by the carrier, not by the agency, and the courts will ultimately determine the meaning and intent behind policy language. The slide that we are now looking at is a very brief overview of Gordon and Reese and their attorneys in Texas. As you can see, we have 3 Texas offices where we have a number of highly skilled and very experienced professional liability attorneys who have defended claims involving agents and brokers in every venue across Texas, not just the larger cities. Currently, Gordon and Reese Texas attorneys are defending malpractice claims in Abilene, Big Spring, Hockley County, San Angelo, Lubbock, and Llano County, just to name a few. These attorneys understand the psychology of judges and juries in smaller venues as well as in the larger cities in Texas. Indeed, right now, and if we go to the next slide, we name a few of the attorneys who are handling these, and there are quite a few. But right now, Bob Bragalone, who is mentioned there, as well as Nathan Pearman, and he's mentioned at the bottom, they just filed a motion to dismiss on behalf of an agency that was sued in a COVID-19 related action claiming negligence and misrepresentation claims. Certainly, the Gordon and Reese Texas attorneys are familiar with the terrain in this new world of litigation against agents related to COVID-19.
Susan, that's really great information, and I want to thank you also for explaining what it is that your firm is going to be doing. Please continue.
I was just going to say that what we're seeing on this slide, this is just a sampling. I wanted to give those who are tuned in some information. And let me also give you just a little bit. I don't practice in Texas, but I've spoken to the Texas attorneys, and I asked them about statute of limitations, because this goes to when might agents and brokers in Texas expect the lawsuits to begin naming them. In Texas, the statute of limitations on a negligence-based claim is 2 years. So from the time that there will be, let's say, denial by the carrier of coverage, and the customer looks to his agent, unless the agent is already named in the lawsuit in conjunction with naming the carrier, a negligence-based claim must be brought within 2 years, and a breach of oral contract claim within 4 years. In Texas, the general law is very similar to that in other states, and that is that a customer has a duty to read his policy and ask questions if he or she doesn't understand the language. Also, the general law is that the agent has no duty to advise absent a special relationship. The problem comes in, of course, and we'll talk about this a little bit more going down the line here, but the problem comes in where agents promise too much, promise that there will be coverage under this policy if the customer buys the policy when there hasn't even been a loss yet. Agents need to remember, once there's a loss, it is the carrier, of course, who is going to make the decision on whether or not to provide coverage.
Susan,
So
Jim, I think it's
yeah.
I think it's great that we're giving the everybody kind of the background of what it is that we've experienced so far, what we know that we probably will be seeing as we go forward. Now, I think it's probably time to kind of talk about to a little extent or to a greater extent. So where do we see the claims coming from? What is it that we're going to be seeing that are going to be the claims that are actually going to be made against agents, and how we're expecting that they're going to be addressed?
All right. As we know, plaintiffs' lawyers are very creative, and claims against agents and brokers may include some novel allegations that we've rarely seen or may never have seen in the past. The question becomes, why would agents and brokers be named as a defendant in addition to the carrier who made the decision to deny coverage for a COVID-19 related loss? And the answer to that is multifaceted. The agent may be named simply to defeat diversity, which precludes the claim from being taken from state court into federal court. There are a lot of plaintiffs' lawyers who do not want to litigate in federal court. It tends to be, in some states, more rigorous, and their burden becomes more difficult to prove. Sometimes agents will be included as a second deep pocket for recovery. Often plaintiffs' lawyers may add an agent or broker hoping that the agent will become embroiled in the coverage question and thus increase the chance that recovery may be made against the agent. And we will talk about this in some more detail in a few minutes, but agents may be included because either on the agency's website or somewhere else in writing, there was a promise of coverage which did not come true, or there was an oral promise of coverage made by the agent which allows recovery against the agent or potential recovery, regardless of the ultimate ruling by the court on coverage under the policy language. We do anticipate a number of lawsuits will be filed in the next 6 to 12 months. Some may be later than that, but we do anticipate a great number of cases in the very near future as more and more evidence comes to light with regard to just how deep the losses are to various, particularly small businesses and those businesses who may not ever be able to recover from this pandemic.
Susan, if I could interrupt just a second, I want to remind the audience that one of the resources that I mentioned earlier, the COVID-19 page of the Big I website, there are several articles there that Chris Boggs has written and various other folks have written about the coverage issues on the BI, in regard to BI and pandemic and everything else. I really want to recommend that you all go and take a look at those articles. There's also been a few webinars about this because that's really going to help you understand why there probably is not going to be coverage, which we understand, but also what, more importantly, from a risk management standpoint, why you should not be the one that is making those coverage decisions, as Susan mentioned. We want to make sure that you understand that the coverage decisions should only be coming from the carrier. That's one of those best practices. When a customer comes to you and they say, hey, we need to, we may have a claim, what should we do? We have already seen, as I mentioned earlier too, that there have been letters coming from carriers telling the agents that you should be denying coverage on their behalf. Well, you are not an insurance adjuster. For the most part, you are not licensed as an adjuster. You do not have authority that authority within your agreement with the carrier to make claims decisions. So be very, very cautious when someone, especially those carriers, want you to make claims decisions for them, because that could very well come back to haunt you. Susan?
Yes, and if we can go to the next slide where we are there. I think that goes to what, Richard, you were just speaking about, and the resource page that was created in March of this year referencing coronavirus and the problems associated and that we might expect to see.
Right. So can you give us some suggestions on how, the agents should respond to their customers?
All right, that really does take us to what we will spend our next 30 minutes discussing, which is, and we have a limited time, so we've chosen really 3 items to focus on under best practices. The first one, Richard, you've already mentioned, as have I, and it's worth saying again. The fundamental issue that an agent should never promise a customer that they will have or have coverage after a loss. Coverage is for the carrier to determine. It's not the agent's duty or responsibility. And here, when we go to best practices, we sometimes call this defensive practices. You don't want to take on more responsibility than the law requires that you have. Why would you be the one to make the coverage determination when the carrier, who actually has the legal right and duty to make that coverage determination, comes up with a determination different from what you have said? That leaves you, as the agent making a promise that goes unfulfilled, vulnerable to a lawsuit. You don't want to state that the claim will or will not be covered when your customer asks. The best thing to do is to tell your customer the coverage will be determined by the carrier, that you will put in the claim if the customer asks you to do that, and then the carrier takes over from there. So that's the first issue. The second best practices issue that we're going to turn to is midterm cancellations, which I think that you can anticipate as carriers deny coverage on these COVID-related claims. Customers may well come to you and say, well, I don't want this policy anymore. I want to cancel it because it's not doing anything for me. It was very expensive and it hasn't covered me. I thought it was going to. I want to cancel. But there are dangers that you want to be alert to so that you in turn can give this information to your customer. What are some of the pitfalls with midterm cancellations? Well, there are a number of them. It may result in an inability to place a new policy. It may result in future coverage denials. It may be in violation of the customer's contractual obligations, which your customer has, but which you as an agent are not responsible for. But it is certainly worth mentioning that to your customer. Midterm cancellation may result in a gap in coverage. It may result in unfavorable pricing. It may result in forfeit or of any kind of refund, depending on the policy language. And it may not even be possible under certain state regulations.
Susan, I want to go back to that last slide before we continue, because the last thing there, the last bullet point says, explain that the insured may be in violation of a contract, lease, or other agreement, and that is not the agent's responsibility to confirm or affirm the insured is in compliance with any signed documents. And Jim, feel free to jump in as well. This is an area that I think a lot of your insurance agents, a lot of the customers that you have may not fully realize that with their lease agreements for the properties that they could be renting or leasing from that there's an insurance requirement, and that by having a midterm cancellation, they could expose themselves to greater liability, not just from them, from the things that they're doing themselves, but also from their landlord. And I think that's something that sometimes customers don't necessarily always take into account.
That's right. But having said that, we want the agents to beware that they don't want to take on, well, I'll read your contract for you, I'll see what it says, and I'll give you advice on that. That's actually, one could argue, practicing law even, but it is for your customer to take the responsibility to review his own lease, perhaps with his attorney, but certainly your customer needs to take responsibility for his own contracts.
If I could just jump in here.
It's very important to mention that to the customer. You may have contracts that preclude you from canceling midterm without being in violation of those contracts. You should look at that.
And if I could just step in here, I would say I totally agree with Susan. We don't want agents asking for copies of contracts to make sure that the coverage is in place as requested or required by the contract. That could be, as Susan mentioned, the job of an attorney. At the very least, it's more the job of a risk manager to be going through and looking to make sure all those things are met. But definitely, it's something to mention to if a customer does come in wanting to cancel midterm, to point out to them that they may be violating some contract that they have. And also, I would just touch on again that even though the carrier may be taking a no-pay position at this point, that doesn't mean that no-pay position is going to hold out based on what the government may do or what the courts may do. Exactly. So it's best to keep that policy in place.
Absolutely.
I think another point that
even consider having a checklist that you can go through with your customers so that you've hit the major points with them, and perhaps even have them sign off on that checklist if indeed they insist on canceling midterm.
Susan, that's a great point, and I want to go back to this slide that we talked about, the resources that are available, because one of the things that we created was, and you'll see right in the center there, it talks about the acknowledgement of policy coverage cancellation letter, acknowledgement of policy coverage cancellation and disengagement letter, and acknowledgement of request to cancel insurance coverage form. These are documents that we've created to help agents when they get that situation where they have a customer that absolutely is requiring that they cancel the policy midterm. And the purpose of this kind of goes back to the basis of everything that we do when we're trying to make sure that we have you do the things to protect yourself, and that's documentation. These are the kind of things that you're going to want to have in your file. You're going to want to be sure that you provide to your customer so that they can acknowledge that they're making this decision, that there is and because what's going to happen is, and what our experience is, that when push comes to shove and suddenly they're at a great financial loss, as Susan pointed out, they're going to start reaching for straws, going after anyone and everyone to try to get that economic recovery for them. The best defense that we have for you to prevent that claim from escalating, but also keeping the claim basically and cutting it off, is these kind of pieces of documentation in your file that will help Susan and the folks from her firm be able to defend you in these actions.
Absolutely.
Susan?
Just to reiterate on that, a well-maintained file is, I can't begin to tell you how important that is in defending these claims. Most of the time, our clients take wonderful notes. They put them into the system, they keep them, and it says telephone conference with customer, advised of the following. Customer's decision was to do X. And there it is with a time and a date and the CSR or whoever happened to be speaking with the customer. And it is very, very helpful in defending these claims and allowing for strong motion practice, either a motion to dismiss or a motion for summary judgment to end the case. So when we're now on slide number 20, and that's exactly right. Document, document, document. Your file can never be too detailed. It can never be too full. So err on the side of writing everything down, placing it in that customer's file, the way you normally maintain your electronic files or however you do them. And knowing that this is going to protect you should a lawsuit be filed.
It's interesting because this really goes back to the very basics of what we've been doing for as long as I've been with the company, and that's been over 25 years. And it really continues for each one of you as you're listening in. You cannot, as Susan said, have too much documentation. You can only have not enough. You need to document each of your interactions with your customers, whether it's a written doc, whether it's a piece of paper. Many of you probably have your automated management systems. Every one of those conversations that you have with your customer by phone, be sure you document them in your agency management system. Those are going to be the best thing that's going to be able to provide Jim in the claims department and Susan in the law when we have to draw her and her firm in to help defend you in these cases. We cannot emphasize it enough how important it is that you have all the documentation of all your conversations with your customer, because that's what's going to make or break this. Susan, let's go on to the next area. And this is agency websites. This is something that we've been dealing with for quite some time in the more recent past. I'm going to say especially within the last 5 years. What can you tell us about best practices for agencies with their websites?
All right, this is very important, and I would encourage everyone listening to go back and take a look at their websites. You may not have looked at it in a year or two, or perhaps even longer than that. Recognize that websites are more than advertising. Websites can be used against your agency depending on the type of language that you're using, over-promising, taking on duties and risks that the law does not put on you, but you've now increased your standard of care. That is, you have increased your duty as an agency or as agents simply because of loose, too broad language that you're using on your website. So why is a website, how can it increase your standard of care? It can create unrealistic expectations. And if those expectations are not met, the customer may sue and use your website as evidence against you. There may be promises that you really cannot fulfill. Those very broad, we will get you the best policy at the lowest price. That is a promise that you may not be able to fulfill. And really, what does it mean? It is so broadly worded, and it can be very dangerous and used against you in a lawsuit. And as is the last item here is, would you want your website statements to be blown up on a poster board as a trial exhibit? So when you go back, hopefully when this is over, sometime this afternoon or this evening, go back and look at your websites and be thinking about that. If we turn to our next slide, we can get into some of the specifics. 22, there we are. Here's some sample language taken from various agency websites across the country. We identify, you're talking about a financial risk, lowest possible cost. Those are broad promises that you may not be able to fulfill. We learn your business. We ask the right questions to uncover your unique requirements. Let's stop there for a minute. You have just taken on the burden of uncovering unique requirements for this particular customer's business. That's a tall order and is probably something how can you possibly do that unless you go into years of their financial documents, you go through all of their business documents. That's not something that an insurance agent wants to take on or should take on or is even qualified to take on. And it goes on to say, we understand your potential for risk. That's pretty broad too. There are risks in every businesses whose customers you serve that you may not be aware of, they may not be aware of. The next one says, we address your need for a comprehensive risk management program. This type of language on a website can be used against an agency under the argument that you are holding yourselves out as a risk manager. A risk manager is something altogether different from an insurance agent. Risk managers have far broader responsibilities, and the client gives them a great deal more information than your customers will ever give you on the business, or that you would even want to take the time to look at. Be careful with the words risk manager or risk management. Here, the next one will produce the most comprehensive plan to safeguard your business. Well, what happens when you sell a policy and, for example, COVID-19, and the carrier decides not to cover the shutdown in that business? Well, the business was not safeguarded. And then finally, we dig into insurance specs to make sure. What about the words make sure? How can you ever make sure as an agent when you're not making the ultimate coverage decision? That's being made by someone over whom you have no control. That is the carrier. So be careful with that kind of language as well. Again, proper coverages, not sure what the word proper means. And that could come back to be used by a plaintiff's lawyer against an agency. If we're on 23, again, our agents were professionals. You are professionals. There's no question. You're licensed professionals. But look at the language. We ensure that you are fully covered. The insurance policy is not your insurance policy, of course. It belongs to whether it's Cincinnati or the Hartford or whoever is issuing that policy. So avoid language that you as the agency are ensuring full coverage. And again, the last one, we will obtain coverage to fully protect the financial stability and assets of your customers. How can you obtain coverage to fully protect the assets of your customers unless you know what all of their assets are? And that would take you into areas that they may not have come to you and requested insurance for. It could be their beach house or it could be any number of things. So beware of this broad language that can come back and be used against your agency by plaintiff's lawyers. Let me just give you maybe a quick rundown on words to avoid. We are experts. Anytime you set yourself up as an expert, that may be used against you to increase your liability because it increases where your standard of care is. We will find you the best policy at the best price. We will take care of all of your insurance needs. Well, what if you're not asked by the customer to insure his car and he has a car accident? He never asked you to do it. He didn't get it from another agent, but because you said that you were going to take care of all of his insurance needs, there is a potential there for a lawsuit. We will be your risk manager. Our relationship is special. We will make sure that you have all the coverages you need. Again, avoiding this kind of you need to avoid this kind of language because otherwise you may be increasing your standard of care to a higher level, that, for example, of a fiduciary, or that of a risk manager or a financial manager. And you may be allowing an argument that you undertook to advise and the customer had a right to rely on you and the customer didn't need to take any steps to protect his own interests.
Susan, I want to that's really great advice. I'm going to show now a slide that I'm going to let you and Jim kind of address and kind of let us know where this came from. Jim?
Yes, this was actually out of a lawsuit on one of our insureds, and we've tried to blank out as much of the language as possible to protect their identity, although these are public filings. But you can see right here that the language off of your websites can and will be used right in the very pleadings against you in court. And here's an example. Susan, you want to talk about it?
Yes, if you just look at, the first paragraph, 26, it says that the insurance agency sold and made certain representations to plaintiffs, and then it goes on. Then we go to 27, and this is important. Plaintiffs relied upon the representations and expertise. And where did they get the idea that the agency was holding themselves out as an expert? We go to paragraph 28, and they specifically cite, they say that the agency promoted on their website, and they quote from it, "We believe our clients' financial security and quality of life," and then they go on to say, "deserve not only dedication, but expert advice." And then it goes on to say, "We will protect you from the unexpected and plan for the predictable." Well, the unexpected, of course, is COVID-19. No one could have expected that to happen. But on this website, the plaintiff's lawyers are twisting the language to use it to their own advantage. But nevertheless, the website does say, "We will protect you from the unexpected." And of course, that didn't happen here because the unexpected COVID-19 came along, the business closed down, lost, according to this lawsuit, hundreds of thousands of dollars, and the carrier said no coverage.
I want to also remind everybody to go back to that E&O Happens website because there is a lot of information there, and there's about language problems, and there's several articles there about things that you can do to have your website take a look at it. Make sure that you're using language that does not use these types of terms. Because as Susan pointed out, there's a flyer there that talks about that. One of the things that we'd also like to suggest to you is that you have your website reviewed. Angela Ford with the IIAT is one of our approved auditors, and she has the ability to go in and if you contact her, she will help you go through your website. She'll take a look at it, do an audit of your website, and they'll determine whether or not there is anything that you can say that will not put you in this position. It's really important that you take note of this because we've been seeing, especially over the last, and Jim, I think you can probably jump in too, the last 4, 5, 6 years, websites really weren't an issue prior to that time. Now, in virtually every case, you're going to see this exact kind of pleading that's going to be attached to the the litigation that's going to quote that language.
Yes, I mean, this was the first COVID-19 lawsuit that we got in our book, the first one to come in, and they'd pulled language right out of the agent's website to throw in there. And, part of the expert defense that Susan's putting together is that pandemics and such, I mean, it's been 100 years, better than 100 years since we've had a major pandemic. And so it's not expected, and it's not something that an agent would have a duty to even speak on or to recommend, because it's been so long since it happened. But when you put out there in writing that will protect you from the unexpected, that sort of negates that defense.
And if you notice on the very last line again, the plaintiff's lawyer has said plaintiffs trusted the agency since they are the experts, taking their own language, with 40 years of experience.
I think as a former trial attorney myself, I'm going to kind of throw in that cynical view that I have, which is that for the most part, I don't think people actually look at these websites when they're making their decisions about necessarily what agent to contact. But I can guarantee you that the plaintiff's attorneys will look at them, and that's the first thing they look at. And they're going to do everything they can to raise that standard of care. Remember in Texas that you only have a reasonable care to obtain the coverage that your customer requested. But as soon as you put language such as this on your website, you're automatically raising that standard of care to that which puts you in a position of having a more and I'm missing the phrase here, but basically that you have become their guardian, that you're going to do everything you can to protect them, and that's not the standard. That's the basic standard of care in Texas. Susan?
That's right. That's right.
I would like to add something here too. A lot of people want to argue, a lot of times I hear insureds want to argue that, well, I'm sure they never read the website, they never looked at it. To get a lot of courts have now ruled on this, plaintiff's bar has taken it this extra step, that the plaintiff didn't have to look at the website and didn't have to rely on it, because to have a higher duty, all it takes is merely holding yourself out as an expert and a higher standard. So the fact that you've held yourself out on a website, that's enough.
That's correct. Yeah,
we've got just a couple more. We've got just a couple minutes left, Susan. I'm gonna think we're gonna cut it off just to remind everyone that if you do have questions, feel free to put them into that chat box and send them to us. Also, if you have questions, there's our there are the email addresses for Jim and myself, and also Carrie Sinevsky at the IAAT. She is your E&O program coordinator. So please, you can send questions to her. They'll get them to us. One of the things that Jim wanted me to make sure that I reminded everyone about is that if you have questions, you don't know if there's a claim or a potential claim or not, feel free to contact Jim or our claims department, because they're there to help you. Their purpose is to not only help you when the claim actually occurs, but also give you some assistance when you're not really sure what's going on. So please feel free to give them a call, and they'll do their best to answer your questions and try to guide you through the process. Susan, do you have any last comments? We got 1 minute left.
My only comment would be that I am certainly privileged to help all of the agents and brokers under the Swiss Re policies. I'm focused not only in defending your interests in litigation, but also helping in any way that we can to help you implement best practices that will protect you from legal claims in the future.
Thanks, Susan. On behalf of Swiss Re and Jim and everybody else at the IAAT, I want to thank you. Josh, I'm going to throw it back to you. I know you've got some last comments.
Well, Richard, thank you so much. And thanks to our entire panel for this great education. I think you've definitely giving us all some homework that we can go back and try to improve our agencies just a little bit. Thanks again to IIAT's lead underwriters, and just a quick reminder that the recording of this session and all of today's virtual InsureCon sessions will be available on the IIAT.org website next Monday. I hope you will attend the next session. It's going to be called Turning Your Agency into Fort Knox at 1 p.m. this afternoon. There's still time to register. Go to iiat.org/InsureCon and click on the registration button next to the session title on the schedule. Thank you so much, and we'll see you all down the road.